Now we will try to understand Depositories Act 1996. Depositories involve dematting of shares, that is dematerialization of shares, as well as transfer of shares from one account to another account in the form of electronic procedure. Let us try to get into these Depositories Act 1996. The paper based ownership and transfers of securities was a major drawback of the Indian securities market, since it often resulted in delay in settlements, delay in transfer of securities, leading to bad deliveries, theft, forgery, etc. So all physical form of share certificates which were used earlier were having lot of inconveniences, lot of problems in terms of settlements, in terms of signatures, forgery, so many other issues. After this Depositories Act has been introduced, the rapid growth in number and volume of transaction in the securities market further highlighted the limitations of handling securities in the physical and paper mode. As a result, in line with the developments of the securities industry worldwide, the paper based settlement and clearing system was replaced with this particular depository system or a scriptless trading system. This transition was facilitated by this particular Depositories Act in 1996. This act provides establishment of depositories in securities with the object of ensuring free transferability of securities with speed, accuracy and security by 1. Making securities of public limited companies freely transferable subject to certain exceptions. 2. Dematerializing the securities in the depository mode. And 3. Providing maintenance of ownership records in a book entry form. In order to streamline the settlement process, the Act envisages transfer of ownership of securities electronically by just book entry form without making securities move from one person to another physically. The Act has also made the securities of all public listed limited companies freely transferable, restricting the company's right to use discretion in effecting the transfer of securities and transfer deed and other procedural requirements under the Companies Act which have been dispensed with. So these have reduced lot of inconveniences and complicated complex procedural issues with regard to physical transfer and settlement of securities. What are the terms which are used in this particular Depositories Act? Let us try to understand. As per the Depositories Act, the first one, beneficial owner. Who is the beneficial owner? He is a person whose name is recorded as such with the depository. The main depositories in India are NSDL and CDSL. So in NSDL, the beneficiary owner name is given as Mr. X. So he becomes the actual owner of that particular securities and which are recorded with the depository in his particular records. B. Depository. Who is a depository? Depository means a company formed and registered under the Companies Act 1956 and which has been granted a certificate of registration under subsection 1A of section 12 of the SEBI Act 1992. So any depository who registers with SEBI under such particular clause will be considered as a depository. So he can maintain the demat accounts or dematerialized securities which can be credited to the beneficiary account are also transferred electronically by these people only. 3. Issuer. Who is the issuer? Issuer means any person making an issue of securities. Generally these are companies. Companies issue securities to the people. So when they issue these securities, those securities are issued in the demat form. The participant. Who are the participants? that is the depository participant, means a person registered under subsection 1A of section 12 of the SEBI Act 1992. Registered owner means a depository whose name is entered as such in the register of the issuer. So, the guy who issues the shares, he registers to whom the securities have been released. That particular person name is considered as the registered owner of that particular securities. No depository can act as a depository unless it obtains a certificate of commencement of business from SEBI board. So, any depository after the permission of SEBI, then only they can carry out the business of depository transactions. The Depositories Act defines rights and obligations of the depositories, participants, generally they are the trading members, issuers, the companies, and beneficial owners which are mentioned under. Now, 1. Agreement between depository and participant. A depository is required to enter into an agreement in the specified format with one or more participants as its agents. So, the depository participants are the agents of the depositories. Services of depository. Any person through this particular participant may enter into an agreement in such form as may be prescribed by the bylaws with any depository for availing its services. Surrender of certificate of security. Any person who has entered into an agreement with the depository should surrender the certificate of security for which he seeks to avail the services of the depository to the issuer in such a manner as may be specified by the regulations. So, if we have any sort of a certificate and we want to use the services of depository to convert these securities into demat form, we have to go through the depository participant. The issuer on receipt of certificate of security, that is the company, once he receives the application for dematerialization through the depository, he first should check and cancel the certificate of security and substitute in its records the name of the depository as the registered owner in respect of that particular security and inform the depository accordingly. So, we are submitting our share certificates through the depository to the company to issue dematerialized shares. So, the company in turns cancels that particular certificate of security and issues the electronically formed securities as a registered owner of depository. Now, however, the beneficiary owner will be on our name only. Now, a depository should on receipt of such information enter the name of the person, that is the beneficial owner, in their own records as the beneficial owner in respect of that security and inform the relevant people accordingly. Registration of transfer of securities with depository. On receipt of intimation from a participant, generally it is a broker, on receipt of intimation from the participant, the depository is required to register the transfer of security in the name of the transferee. If a beneficial owner or transferee of any securities seeks to have custody of such security, the depository should inform the issuer accordingly. These are the procedures with respect to transfer of securities from one person to another person by the depository through the depository participant. Options to receive security certificate or hold securities with depositories. Every person subscribing to securities offered by an issuer should have the option either to receive the security certificates or hold securities with the depository. When a person opts to hold a security with a depository, the issuer should intimate such depository the details of allotment of the security, and on receipt of such information, the depository should enter into its records the name of the allottee as the beneficial owner of that particular security. Securities in depositories to be in fungible form. All securities held by a depository should be in dematerialized and be in fungible form. That means any shares which are there in this particular demat account or depository account can be used to be bought and sold in any areas, and these securities can be used to sell in any particular market as required by the beneficial owner. Rights of depositories and the rights of beneficial owner. So, please remember, depositories are maintaining the securities of the beneficial owner in their account. So, they become the registered owner of that particular security, but the main beneficiary is we, the securities which are on our name. We become the beneficial owner, and these processes are carried out through the depository participant. What are the rights of depositories and beneficial owner? A depository is deemed to be the registered owner for the purpose of effecting transfer of ownership of security on behalf of the beneficial owner. So, the depository is only acting on behalf of the beneficial owner. The depository as a registered owner does not have any voting rights or any other rights in respect of securities held by it. So, they are just taking responsibility of holding the securities in the demat form, but they do not have any sort of right or voting rights on those particular securities, because the beneficial owner are someone else. The beneficial owner is entitled to all the rights, benefits, and subjected to all the liabilities in respect of his securities held by a depository. Pledge or hypothecation of securities held in a depository. So many securities the investors are having with the depositories. How these securities can be pledged? A beneficial owner may, with the prior permission, approval of the depositories, create a pledge or hypothecation in respect of a security owned by him through this particular depository. So, if I have got some shares with the depository, I have to take permission to use those shares for the purpose of pledging or hypothecation. Every beneficial owner is required to give intimation of such pledge or hypothecation to the depositories, and accordingly the depository will make entries in its particular records. Any entry in the records of a depository would definitely act as a evidence of a pledge or hypothecation. Ninth point, furnishing of information and records by the depository and the issuer. Every depository should furnish to the issuer the information about the transfer of securities in the name of beneficial owners at such intervals and in such manner as may be specified by the bylaws. Every issuer should make available to the depository copies of the relevant records in respect of securities held by such particular depositories. 10th point, option to opt out in respect of any security. If a beneficial owner seeks to opt out of a depository in respect of any security, he should inform the depository accordingly. After receiving the information, the depository is required to make appropriate entries in its records and inform the issuer. Within 30 days of receipt of intimation from the depository and on fulfillment of such conditions and payment of such fees as may be specified by the regulations, the issuer is required to issue the certificate of securities to the beneficial owner or the transferee as the case may be. So, anyone can opt out of all this procedure from depository and ask for issue of certificate of securities. Depository to indemnify loss in certain cases. In case any loss is caused to the beneficial owner of these particular securities due to the negligence of the depository or due to the negligence of the participant, the depository has to indemnify the beneficial owner. Where the loss due to the negligence of the participant is indemnified by the depository has the right to recover the same loss from such participant. So, anything mistakes or any problems are taking place for the securities which we own, the depository will have to indemnify for the loss that has happened, and later the depository can tackle or settle with the depository participant as the case arises. So, these are the major points, rules, regulations, procedures about the Depositories Act. Indian Contracts Act 1872. A contract is an agreement between two parties or maybe multiple parties. So, what are these contract rules and regulations which are framed in this particular securities market? Let us try to get into all these details. In securities market, the Securities Contracts Regulation Act, popularly known as SCRA, governs contracts for or relating to purchase, sale of securities. However, the provisions of the Indian Contract Act 1872 also have a bearing on these securities contracts, as this is a general act which governs the rights of parties in a contract and the effects of such contracts thereof. There are some important terms, definitions which are used in this particular Indian Contract Act. This we are supposed to understand. First, contract. What is a contract? According to section 2H of Indian Contracts Act 1872, a contract is an agreement which can be enforced by law. Therefore, there has to be an agreement to create a contract, and secondly, it has to satisfy certain requirements mentioned in section 10 of this particular act. That is, the agreement has to be between parties competent to contract with their free consent for a lawful object and with lawful consideration, and it should not have been expressly declared as void agreement. That means, it should be for a proper issue and it should be among two competent people in this particular contract. Such contracts are enforceable by law. 2. The standard form contracts. With an enormous increase in commercial transactions, the concept of standard form contracts has come into existence. Various business organizations like insurance companies, airways, securities market regulator, other businessmen, etc., generally get the terms of the contract printed on a standard form, and the other side is simply required to agree to the same conditions, or sometimes to sign in token of his having agreed to the terms of the contract so drafted. That means, the agreement will contain all the standard terms and conditions of the contract which are mentioned on one particular sheet, and the second sheet is left for signatures, etc. A standard form contract is a pre-established record of legal terms regularly used by a business entity or firm in transactions with their customers. The record specifies legal terms governing the relationship between the firm and the another party. the firm requires the other party to accept the record without amendment and without expecting the other party to know or understand its terms. A standard form contract is effective upon acceptance. So, any company can design a standard form of contracts and it has to be accepted by both the parties, which becomes a standard form contract, and this is effective on acceptance only. Third, agency contract. An agent is a person employed to do any act for purpose of another's responsibility or another's business, or to represent another in dealings with the third person as per section 182 of Indian Contract Act 1872. So, a company to carry out its transactions, they can appoint an agent to act on their behalf and enter into contract act. Fine. The person for whom such act is done or who is so represented is called the principal. Principal is bound by the acts done by such an agent who is acting on behalf of the principal, or the contracts entered into by him or behalf of the principal in the same manner as if the acts had been done or the contracts had been entered into by the principal himself in person. So, any acts of the agent of this particular principal will be considered as if the act has been done by the principal himself. An agent has a dual capacity. One, he serves as a connecting link between the principal and the third person, and second, he can have a contractual relationship with this particular principal. An agent having an authority to do an act has authority to do every lawful thing which is necessary in order to do such an act. So, an agent is having an authority to carry on a business. He has an authority to do every lawful thing necessary for the purpose of the business, or usually done in the course of conducting such business on behalf of the principal. So, agent is a pure representative of the principal, and all the acts of the agent will be considered as the act of the principal himself. Now, there can be a subagent also. A subagent is a person employed by and acting under the control of the original agent in the business of the agency. So, this particular agent can also take up the support of another subagent to act for the purpose of carrying out the business. Though the general rule is against delegation of authority by an agent or appointment of a sub-agent, there could be such an appointment in exceptional situations recognized by law. Thus, any act does not need personal performance by the agent himself, or the principal agrees to the appointment of a sub-agent, or the ordinary custom of trade permits the same to appoint a sub-agent, or the nature of the business of agency so warrants. Nature of the agency so warrants, a sub-agent may be validly appointed by an agent himself. When a sub-agent has been properly appointed, the position of various parties is as under. 1. The principal is, so far as regards third persons, represented by the sub-agent and is bound by and responsible for his acts as if he were an agent originally appointed by the principal. That means, this sub-agent acts as the real agent of the principal himself. Second, the agent is responsible to the principal for the acts of the subagent. 3. The subagent is responsible for his acts to the agent, but not to the principal except in case of fraud or willful wrongdoings. So, the subagent is working on behalf of an agent, but any mistakes, any frauds a subagent does, it will affect the principal himself. So, these are the details with respect to Indian Contracts Act.